and all our Wednesday newsletters. Each of those newsletters are a little bit different. The Monday ones typically include tips, and what we see in the NIL space are really three main actors: student athletes, athletics department personnel, whether that's administrators, but that could even go more broadly as university general counsel offices as well, and university presidents and the like. And then obviously agencies and any type of representation firms as well. So in those Monday newsletters, we look at more tips for them. We also have specific news for each of those stakeholders, whether it's AT has signed such and such athlete at Excel, or here's a new policy that a couple of schools have been using. Perhaps that might be good for an athletic department to adopt. And then off of that, we also have a growing website where we have a couple of trackers that are currently in the works. Obviously, one that focuses on NIL legislation and what agencies are doing and what agencies need to follow depending on what state they're in. And there's also other basic educational resources. And tomorrow we're actually going to be unveiling a tax consideration worksheet as well. And then all those things considered, we also more on the consulting side of things, working with schools directly. I think right now we're seeing in the next few months, we're going to see a lot of athletic departments realize that some of these education programs that are currently in the works tend to be a bit too cookie cutter, a lot of PowerPoints, not really targeted at student athletes. And we think the need for student athletes is going to be less on, general, here's how you sign a deal and stuff like that. More, this is what actual legal advice you might need. We may actually need to look at these deals individually, and more broadly, how athletes can expand more on the content creation and other sides. So that's really all that Optimum Sports Consulting is as a whole.
Great, thank you. You hit on a lot of things there that I hope we can get to in the rest of this discussion. So moving forward with that, so following the Alston decision this past summer, the NCAA announced its interim NIL policy, basically, which required student athletes to follow their state laws when engaging in NIL activity, if there were even state laws, and then prohibiting still pay for play. Basically, this left the NIL game wide open for athletes to make deals with few restrictions. So as in the past only 4 to 5 months of the NIL industry, there have already been administrators, college administrators, NIL experts, agents, and other personnel pushing for more consistency in NIL regulation as this new phenomenon moves forward. So kind of want to ask each of you, how this inconsistency has affected your work and your company. So Khalil, I'll start with you. So does this lack of consistency in rules and regulations pose any challenges for MOGL? And do you think that a national NIL policy will help your platform maybe make connections easier, make things more fluent? Yeah, can you just speak to that?
Sure. I think from my end, personally, it definitely adds a lot more work to my table, mainly just being that resource for a lot of different universities in a lot of different areas. And that's just not geographically, right? We have Division I, Division III student athletes as well. So understanding the consistency in laws and regulations for each university as well poses a challenge for me in terms of my work, but also poses a challenge in our marketplace platform when telling, at least businesses on, something that is permissible for one student athlete may not be permissible for another student athlete, correct? So just letting them know and kind of helping them out with their expectations, managing those expectations to say, listen, at the end of the day, these are still subject to NCAA rules, state laws, and university rules. So for my end, it's more so getting in front of that communication early so that they can understand that, listen, depending on what the student athlete is or where the university is, there is going to be some lack in consistency. However, our focus is local at MOGL. You may see us, we're going to be going out actually to Austin, Texas, coming up in November 15th to 17th. I actually just got done visiting Ann Arbor. We are setting up local business around the campus, obviously looking for engagement. A lot of those local businesses want to give to the student athletes. And of course, for a lot of our student athletes that aren't in the high revenue sports, it also allows them in their sport to be seen by the local community, right? So that lack of consistency isn't really shown as much when you have that focus, because they understand that they're really working with a certain amount of universities and at least state laws, hopefully keeping it within that. And of course, a national policy would absolutely help everyone. I think that it would help, especially compliance officers on campus being in that role, understanding where we are compared to other universities, right? And obviously a national policy will help with compliance, but also help with institutions in planning how they're in a NIL and how they can be the best resources for their specific student athlete. There's always a rat race, obviously an arms race to win in recruiting. I think that a national policy obviously would help at least all universities feel like, okay, here's a standard where we can go, how far we can push, and moving forward, make their lives a lot easier outside of just mine.
Great, thank you. You mentioned something there. You said, you primarily deal with more local deals, working with certain universities, so they all the athletes at that university are under the same rules and regulations. Do you think with and I think across the board in NIL, that's where we've seen a lot of the deals more localized. Do you think with the introduction of a national policy, deals will become more national, or do you think it'll stay more localized like they are now?
I think that it will just only add to the opportunities that are provided, right? So it doesn't mean that somebody from Michigan can't get that same local opportunity in Ann Arbor, but there's a situation out in Somerset, New Jersey. If they're from that state, why not have a national policy to where at least the student athlete understands, even though I'm still, my NIL is attached to my university, even if I'm in New Jersey, that I'm A-okay in terms of compliance wise. So I think that for most part, it'll help universities. I'd even mention the student athletes, with them at least knowing, okay, this is where we can push.
Great, thank you. AT, if you don't mind speaking next on this, how does the inconsistency, at least between state NIL laws, and I think you touched on this a little bit in your last answer, affect the legal activity in NIL, and what do you see, and are you and your agency hoping that a national policy will help? Yeah, can you speak to that?
Yeah, I mean, look, as Khalil said, like our job in compliance obviously gets more complicated as you break down school by school NIL policies, and I undoubtedly think a national policy would help. I think right now schools can have the same verbiage in their NIL policies, but how you interpret that language per situation is dependent on schools. And I've been in situations where we're doing the same deal across multiple schools, and how, let's say, pay for play language is interpreted is different, because there's no proper definition of that. Does pay for play mean any kind of compensation can't be tied to athletic performance directly? Does the compensation have to go directly to the student athlete? Can a donation be made tied to play on the field? Right? Like it's a plethora of interpretations of the same policies and the same rules. And what clarity would do is make the recruiting and competitive fairness landscape equalized. Because I mean, I don't think anyone's kidding themselves on this call. For every college compliance department, this is about recruiting. That is what NIL is about. It's no longer look at my locker room, look at the game room, look at the roster we have. Like a big part of this is, what can I do in my 4, 3, 2, 1 years at this university to capitalize off of my NIL? And without consistent rules guiding that, it not only creates an unfair landscape, like in South Carolina, not allowing any school marks at the state level. The DJ was on that Dr. Pepper commercial, right? Had no Clemson logos at all. If you were allowed to have Clemson logos, presumably the contractual numbers would have been higher because he would have been more recognizable as an athlete. And so having national consistency is definitely better. And I think, speaking on the high school space, obviously XL made a splash signing Mikey Williams. I mean, that's when it gets even more rocky. I think Oliver's talking about this before. I mean, California is statewide as far as high school athletes being allowed to receive NIL compensation. I believe New York and Illinois is allowed at the state high school athletic association level. 2 states deny it at the state level, but then every other state, it's like there's no answer. And there's nothing in these bylaws that indicate that there is an answer, because at the high school level it's never thought about. So for sure, across the board, I think NIL would benefit from a national policy.
Great, thank you. Yeah, you touched on the high school aspect. I hope to get to that a little bit later, so we appreciate that. Austin, after Optimum's review of NCAA's first proposal ahead of the Constitution Convention next week, after going through that and seeing what's ahead, do you think there's something that can come out of the convention that will help provide more consistency in NIL regulation for college athletes?
Sure. I mean, the thing about the Constitutional Convention and the draft proposal is that there's a lot of things, not just NIL, influencing that as well. I mean, as Oliver talked about, there's conference realignment. There's a ton of things at play, and name, image, and likeness is just a part of it. In the 21-page draft, name, image, and likeness is only mentioned 5 times. The first time is a preamble, which to some extent is significant in the sense that, this was something that the NCAA, has significantly changed their position on. But we already saw that with the interim policy released, right at the start of July. So that wasn't too much of a surprise. I'll skip to the second time because I think that's the most significant. But the third, fourth, and fifth times, it's mentioned literally copy and pasted from each section, one after the other. It essentially says that both each division, each conference, and each institution have to maintain written policies. And that's about various things with NIL, whether that's advertising, commercial agreements, sponsorship, and stuff like that. To my knowledge, I would assume that every school has already done that in some capacity, working closely with their general counsel's office. I mean, this is IP, and as AT mentioned, schools have to protect that, and they'll decide if you can use school colors but not logos, if you could use facilities. These are all things that schools have to consider, and the NCAA mentioning that is important, but not really much of a surprise. The second time it's mentioned, though, on page 4 of the draft is probably the most significant. And that's because what it's saying is it references the collegiate student athlete model. And at the beginning of that, it quite literally says student athletes may not be compensated by a member institution for participating in a sport. It goes on to talk about educational benefits, a la Alston, and then it talks about NIL, which is of course the interim policy. But the idea of the school not being able to pay the athletes directly is core to the NCAA's argument. It's always been the NCAA's platform. And it's basically, what Mark Emmert or whoever from the NCAA always advocates for, certainly on Capitol Hill. The issue is that there's multiple things happening right now at the federal level and at the state level that could significantly change that. Of course, we saw the NLRB essentially reversal from their stance on Northwestern football unionization, basically saying that, they could treat, student athletes as employees. And I think what's much more significant, and I'll probably touch on a little bit later with a more clear analysis, is the case currently going on in the Eastern District of Pennsylvania, which essentially calls both the NCAA and member institutions joint employers of student athletes. So while this is in the Constitution, it certainly looks like there's a chance that, if student athletes are considered employees, that, whatever is said in this draft constitution doesn't really matter because, the court of law will say it differently. And AT and Khalil are on this call, and they're both lawyers, so they know this better than anyone. But Eastern District of Pennsylvania, Philadelphia, very plaintiff friendly. It's no surprise that even most legislation has come out of San Francisco in the the Ninth Circuit. But there was a case just a few years earlier that completely disagreed with the analysis that's coming out of Pennsylvania right now in just a 3-year time frame. So in terms of a national policy, I'm not really sure it'll matter as much as quite literally what the legal implications of this be. We saw with Alston in a 9-0 decision, but I think what we're seeing in this Johnson case that's coming up will be much more significant on the impact of a national policy than anything in the NCAA draft constitution.
Great, thank you. You said a lot of great stuff there. I think we'll hopefully touch on some of it too, as we have a few more questions here. So, as I mentioned before, when I was speaking with AT, a lot of these student athletes don't have representation, don't know to get representation if they're a high profile enough athlete. So they don't really have anybody if their school doesn't have an educational program. And even if it does, like you guys mentioned, it might be very cookie cutter and doesn't really hit on things like explaining to them their branding rights, deals they're prohibited from signing by state or school laws, or even if, generally speaking, they're not entering into a good contract or not. So what are some things that you guys advise student athletes to be mindful about when they're engaging in NIL activity? And then Khalil, you know, for you who deal more with businesses, like what do you